part of our audience might be people who are thinking about being clients, is that at the application and reconsideration level, Social Security orders medical records for you, for the claimant.
Right.
But at the hearing level, they stop doing it. And as you mentioned earlier, it can be as short as 8 months, but as long as 18 to 24 months. I mean, I've seen some locations, I think Baltimore is like at 28 months of wait time, and Social Security stops ordering those. And so one of the things you talked about is like, hey, look, we have to go in and look at what Social Security stopped ordering, and now we're going to go order it. Good morning, John. How are you?
I'm good. How are you doing, Pete?
I'm doing great. Thanks for asking. So I really appreciate you spending some time with me this morning because, I do know how busy you are, especially you. So you have been promoted and have really been a kind of a shining light in our firm. And one of the things that I've noticed and that really speaks volumes to you is not just that you're hyper intelligent and have all the makings of what's going to be a great lawyer from an intellectual standpoint, but also that you care, and that you want a rewarding job. Yeah, excuse me. And so, and you care about our clients, and you care about not just the case law of it all, but how does this affect their life? So what does the director of case management do?
Yeah, definitely. So hearings level, once somebody's denied at the application level, obviously we appeal that for them. They go to the reconsideration stage. And then if they're denied again at reconsideration, that's when we request a hearing before an administrative law judge. And so I assist clients throughout that whole process, which tends to be the longest part of the process in general. We request that initial hearing, and then depending on the hearings office, it can take anywhere from 10 to 18 or more months for us to actually get to that hearing date, sometimes even longer, depending on where we're at. But at that initial level, the process will request a hearing for them, and then there's probably going to be some wait time before we really hear anything. Social Security sends out some forms regarding the type of hearing that they're going to have. We typically recommend that our clients do phone hearings, which is a fairly new option that the hearings offices have, and we've just seen a lot more success with those phone hearings. So one of the forms that's going to come out is a right to object to a video teleconference hearing. So we usually recommend that our clients do object to that, and then we try to get most of our hearings scheduled to take place over the phone. I think that there's a few advantages to that. And then we do spend some time waiting till we get that notice of hearing, which is when the work really starts with those clients. We get that notice of hearing usually about 3 or so months prior to the date of the hearing, I would guess.
There's a legal requirement that the notice of hearing, as you know, there's a legal requirement that the notice of hearing comes a minimum of 75 days before the hearing, but a lot of times we'll get it before.
Yeah, I think it's about 90 to 100 is usually a good guess, around 3 months out. And then once we get that notice of hearing, that's when we actually have to start doing some real preparation. And at that point, our team, usually me, will reach out to the clients and discuss their notice of hearing, the date and time, make sure that they're aware of when that's happening, where that's happening, if it does happen to be an in-person hearing, discuss the manner of appearance, if it's a phone hearing, a video hearing, and then discuss options for switching that, if that's what we want to do. And then the key part of the process that I assist the most in is updating and collecting medical records for our clients. So usually around 6 to 8 weeks out, we'll schedule an appointment over the phone or Zoom. Some people do prefer Zoom, and I totally understand that. We'll set up an appointment and go through their entire medical record file with Social Security, which sometimes can go back 5-10 years. And I'll just go piece by piece through that, through each facility, each provider, and check with them what's missing. I know that when we request a hearing for our clients, Social Security will pretty much always stop collecting their medical records for them.
Right.
So at that point, we've got some some work to do filling in the gaps.
Right.
So that's one huge benefit of having us represent folks, is that they don't have to do any collecting of their medical records. They don't have to go get their file. And we kind of do a deep dive into that with them.
Right. And why don't you tell our clients, and let's back up just a little bit. I did a whole podcast and video on why we believe phone hearings are actually better than in-person hearings. And what's your perspective on that aspect of it when you talk to clients like, hey, look, you could go in person, and there are times where in person might be better, but I do think it's a small majority of the time. What are some things you'll tell our clients about phone hearings versus in-person hearings?
Yeah, absolutely. So I think that there's two different main benefits. The first is just logistical. It's going to be easier for you. You're not going to be as anxious and stressed out for that day if you know that you're just answering a phone call, and you can do it from the comfort of your own home. It's less likely that you're going to miss it or something's going to go wrong. But I think the primary benefit is strategic, and that's that the judge is not actually looking at you, and you're not appearing physically or via video. You're really just on the phone. And I think that what I've learned and what I have noticed with in-person hearings is that sometimes those judges will tend to develop opinions of your ability to work based on the way that you look, which
Right.
is not a reflection of your conditions or your ability to work almost all the time.
No,
Yeah, I think there's some discrepancies between visual appearance and what people are actually going through on a
Yeah.
daily.
Yeah, I agree 100%. And they're judges or human beings, and they're going to make a first impression based off of how you look, how you sit, how you move in that hearing room, which, in many cases, as we're trying to argue about, years of disability at a hearing level. And they're trying to judge a person on a, 45-minute or a 60-minute observation, which legally they're not even supposed to do that. But of course they do. I mean, they're human beings. The other misnomer I think that you brought up too, which is, part of our audience is our current clients, and part of our audience might be people who are thinking about being clients, is that at the application and reconsideration level, Social Security orders medical records for you, for the claimant.
Right.
But at the hearing level, they stop doing it. And as you mentioned earlier, it can be as short as 8 months, but as long as 18 to 24 months. I mean, I've seen some locations, I think Baltimore is like at 28 months of wait time, and Social Security stops ordering those. And so one of the things you talked about is like, hey, look, we have to go in and look at what Social Security stopped ordering, and now we're going to go order it and provide it. Tell me a little bit about how you even access the file. Tell our clients a little bit about how you access the file.
Right, absolutely. So when we are the representative on file for a claimant with Social Security, they give us access to the electronic file that they have, which is through a system called Electronic Records Express, which I believe is only for attorneys or non-attorney representatives. So that gives us direct access to every single piece in your file, every document. We can download those to PDFs. We can open them up. We can search through them. I mean, it really just makes it so much easier for us to figure out every doctor you've been to, the dates of service for all of the medical records that we have on file. And that system makes it possible for us to very easily compile a list of, at the very least, the places that you've already been going for treatment. And then we can also figure out 3, 4, 5 years in the past if they missed something. If Social Security never collected some vital medical records from a doctor or a therapist or somebody that diagnosed you with something. I mean, that file really just gives us a starting point so that we can make sure that the file is actually complete when we get to the hearing.
Right. And then there's multiple sections in that file as well, because there's stuff that's been exhibited. Means Social Security has recognized the document, they've organized it and assigned it an exhibit number, like 1F, 2F, 3F. And then there's another section of that file that's called case docs, that are docs that haven't been exhibited. And the advantage of having an attorney represent you is we have access to both of those. Where I think if you're not represented, I think you have to, they just mail you like a CD, and you have to open up, and I think you get what's exhibited, not necessarily what's not exhibited. It's been a long time since I've seen a CD, but I believe that's how it works. And a lot of times we'll see some evidence in case docs, and we need to remind Social Security, hey, go exhibit this. It needs to be considered so the judge can see it. So yeah, let me ask you this about the process of ordering medical records, because this is something that's, I think everyone should know. One, from the date you order it to the date the medical record comes in, how long on average at different facilities does it take, and kind of what are you seeing around the country?
Yeah, absolutely. I think that there is a big range. Some of these big facilities like OHSU and Kaiser, if I send in a request and I mark it as urgent and I follow up the next day, we might get the records in 48 hours. But I think a reasonable average to expect is 2 to 3 weeks. Those records should be back in 2 to 3 weeks, but it can definitely be a bit longer. And I think that the places that we see it take the longest can be therapy offices, physical therapy, counselors. A lot of mental health facilities are a bit slower because they're just sending out less records in general, and B, a little hesitant to send records sometimes. So sometimes we have to contact them and advise them that the judge needs to see all of the records and that it's critical to the case. But I do think that a good general estimate is 3 weeks. 4 weeks is starting to get a bit long, and then that's when we really need to start figuring out what's going on with the medical records facility.
What's the longest you've seen a request for medical records take?
I've seen, a request that's been lost, which does happen. Sometimes a request will get completely lost. It can take 2.5 months with multiple follow-ups, and we eventually get them because it was lost to the facility. I think there's definitely some states that are slower than others as well. California is notoriously slow in my experience. So it can be 5 to 6 weeks. And I think my expectations are a little bit lower for those facilities. But yeah, I think that it can take up to 2 months. In some
right. So it's really important for not just our firm and our clients, because luckily they have you and your team to kind of go and chase these medical records down and follow up on them. But if you get a notice of hearing in the mail, and let's say, it's 75 days out or 80 days out, you need to know what's in your file ASAP. If you're not represented, look at your file and then see what's missing and understand the date range of what missing, and then order the medical records directly with the facilities that you've gone to that are missing, but know in the back of your head, like, hey, you may need to give them 3 to 6 weeks, depending on kind of where you live and the organization, but don't just let it go. Like, you need to follow up if it's like, hey, we're now 5 weeks, 6 weeks out, because one of the big quintessential pieces of your work is if they don't come in, there's a rule that says we have to inform the judge. And what's that letter called if they're not in?
Right. So that's commonly referred to as the 5-day rule. And so we've got the 5-day letter. So it's 5 business days before the hearing, which is a week before the hearing. A letter needs to be written to the judge to inform them of any outstanding evidence. So if we ordered medical records from 3 different facilities and we got them back from 2, but we're still waiting on the records from Providence or Kaiser, whatever it may be, we need to send in a letter to the judge saying, we're still waiting on these records from Providence. It covers this date range. We've done this, this, and this to try to get those records, and the facility still has not released them. And that letter is critical, because if we don't submit that letter and inform the judge of the outstanding evidence, then they're not going to accept it after the hearing. More likely than not going to accept anything that's not included in that letter.
Right. So if you have missing medical records and you don't at least inform the judge about them before the hearing, the judge has the option at the hearing then to say, hey, look, you didn't follow the 5-day rule or the 5-day rule letter. you may have a year's worth of missing medical evidence that would be crucial for the judge to make a decision, especially if there's, really overwhelming evidence in support of disability. You would then be denied because the judge didn't have that evidence, and it's well within the judge's legal right to do so. And the history of that rule, as you know, is that before the 5-day letter rule, lawyers or clients would walk in and say, like, hey, I've got a year's worth of missing medical records, and the judge would have to postpone the hearing. And then Social Security would get in a lot of trouble for having these very aged cases. So they're trying to, make the cases go faster, and make people be accountable to getting in the evidence so the judge can review that. So that's important as well. Other things too that you do, other than just ordering medical records, that I think if you could tell our audience, like when you open up that file, what are other things you're looking at other than just what's missing in the medical file? Like, and I didn't kind of throwing this out at you, but like, I know one of the things you look at is it's Title II, Title 16, what's relevant, working, things like that. Maybe if you could walk people through kind of that process that goes on for you.
Absolutely, yeah. So when we open up your file in ERE and take a look at it, up at the very top, it's going to have your name, your Social Security number, but also the claims that you have open. So there's the Title II and Title 16 claims, and obviously those are two very different programs functionally. So first of all, just opening that up, I'm going to take a quick look at what you've applied for. So if you have a Title II only claim, which is the Social Security Disability Insurance, we know that there's going to be a date last insured by the program on there somewhere. It might be in the future, and you might just need to demonstrate that you're currently disabled at the very minimum. But there's also plenty of clients that I speak to at the hearing level, and I take a look and I see that the date that they were last insured by Social Security Disability is in 2020 or 2016. So noting that is extremely important because that's the date that we need to prove you became disabled on or before. Right. And then obviously also I'm looking at financial information. I'm looking at the date that you applied, the date last insured, like I said, the date that we're alleging you became disabled. And also it happens sometimes that somebody will allege in their application they became disabled 15 years ago, but the medical records in the file start 6 years ago. So there's really no winning that alleged onset date that we've got. So sometimes I'll have to say, do you know where you were getting medical treatment 15 years ago when you first started experiencing these conditions and weren't able to work any longer? So just noting little things like that most people probably would not be able to catch even if they had their file. It's all really easy to access in the Electronic Records Express, and those are all things that we're checking on every time we meet with a client.
Right. And then, one of the conversations we'll have with people as well is, if you allege disability 15 years ago, but you just applied 2 years ago, it's not even relevant to go back 15 years. It's not necessary because, and I don't want to get into too many financial stuff with, I'll have a podcast with Haley about that, but, they'll only pay you back so far. Like for Title 16 cases, it's the furthest they'll pay you back is to the filing date. And then for Title II or disability insurance benefits cases, the furthest they'll pay you back is 12 months prior to the filing date, plus you have to take into consideration the 5-month waiting rule. So, there's a lot of things that I know we ask you, or I've asked you to quickly analyze when opening up a case file, which goes to your analytical brain of yours. But, and even if someone is working, that analysis about, okay, what evidence do we need? Or if someone's in school, like getting college education, because you do order more things than just medical records often, which are, what other types of things will you end up ordering for our clients?
Right. I think employment records can be very important. Like you said, school records can be very important. With employment, I think especially sometimes we'll send a letter to a previous employer requesting maybe the firing letter that they got, an explanation of why they were terminated, their pay stubs. We might need school accommodations, their transcripts from when they were in school.
Right.
There's a handful of different things that are outside of the medical realm that still might be needed and could be definitely relevant for the judge to look at.
One thing thank you. Great answer. Because we do ask you to order, you do order a lot more than just medical records in many cases. And a lot of times too, we'll have talk to the client and say, do you have a supporting doctor? And we'll send one of our opinions out to that supporting doctor to see if they can get it filled out for the hearing and get that in as well, which can be amazing evidence. One of the things I was just thinking about for our folks who are not represented, tell them how easy it is for you, because our clients are represented. So you actually, once you get the medical records, to submit them. Because what do? Just the act of submitting them.
It's unbelievably easy for me. Most of the time for these big facilities like OHSU, they will send me a secure PDF document. I open it up, I type in the necessary password using their format, download the file, name it, and add the dates, and then submit it. And it takes me 1 minute maybe.
And you submit it via ERE as just like you upload it directly to Social Security, directly to that client's file.
And the valuable part too is we get receipts from that as well. So we get an electronic receipt. We can prove that it's been submitted if for some reason there's an issue with the date of the submission or it not showing up in the file. Like, we have an actual document showing that it was submitted to their file on a certain date at a certain time.
Right. And if you're not represented and you don't have access to ERE, I think either you have to personally go drop it off,
right,
or you have to fax it in or maybe mail it in. And our experiences with either dropping things off, faxing it in, or mailing it in, what typically have you seen happen when we've had to do faxes and things like that?
Faxes are not a safe way to send things to the hearings office or Social Security. I mean, it's definitely a second option when we don't have access to the ERE. Sometimes it'll be down and I'll fax something and then submit it to the ERE the next day just to be safe. But faxes get lost, faxes fail. Things get lost by Social Security an unbelievable amount. And I think that anything that's not electronic and electronically confirmed is not fully trustworthy.
Right. So then within our for our clients, once we get all the medical records ordered, and I know our clients have access to videos on our website to help we did a mock hearing video. We send them a kind of a pre-hearing conference video. We then assign them to one of their lawyers, and every one of our lawyers has, we have a former Social Security judge who's doing hearings for our firm, for our clients, to people who have done thousands of hearings. So, I know that most of our lawyers, they are extremely experienced. What's next for our clients after that medical record and what internally we call the F-section review or file review? What's next for our clients to expect?
Right. So at that time, like you said, I'm going to send them out a pre-hearing packet. The pre-hearing packet is extremely useful. I think that covers a lot of the questions that folks have that it would take me a long time if I answered all of those questions for every single client I meet with. And I think that packet answers a lot of those questions a bit better than I might over the phone.
Right.
Got useful information on how to answer questions, what types of questions to expect, how to write a testimonial letter, the timeline. I think that the pre-hearing packet is very important. So they're going to get that after we collect their medical records. And then at that time,
the sample questions
right.
in that packet. I mean, a lot of people want the sample questions because, those sample questions I wrote out after I've done about 6,000 or 7,000 hearings. Right. And those are generally the types of questions. Now, every hearing is a little unique, so I can predict 95% of the questions the judge will ask. So that 95% of the questions are in that sample question packet, which is, something that we give to our clients to help prepare them. But go ahead. I'm sorry to interrupt. So then they get the pre-hearing conference packet from you, kind of the list of videos and links to all that. And then what else can our clients expect?
And then they can also expect that they'll find out who their attorney is going to be. I might know, and they might know before that meeting to collect medical records, but at that time, I'll definitely let them know, oh, see, we've assigned your case to Dan Hyatt. He's a former Social Security law judge. I'm going to get you set up with an appointment to speak with him about 4 weeks out. So that's usually about 2 weeks from the time that we're collecting medical records. So I'll add that to Dan's calendar as he's available, get them set up to meet with the attorney, and then kind of set some expectations for when we can expect the medical records to be back. If there's any follow-up that they need to do, like if we determine that they've got a doctor who is willing to fill out a questionnaire, I'll send them that questionnaire. Essentially, at that time that we collect medical records, we get everything set so that there's really no questions that they should have left for anybody other than their attorney.
Yeah. Yeah. And then if they want a deeper case analysis, we actually just, we hired a non-attorney rep who has worked for the firm for years, who's done hearings for the firm as well. And they can go in and set their own appointment on our website through Calendly on the Contact Us page. And you give them the username and password. It's on the pre-hearing conference packet. And then they can just log in, set an appointment, and they can do sample questions with Mervyn, or they can do, they can talk to Mervyn about their case in specific, and can hopefully help kind of walk them through that, or contact the lawyer they've been assigned to as well. But Mervyn's probably the easiest that they can just set the appointment. So then after all of that, they go and then they meet with their lawyer. We do the pre-hearing conference with the lawyer, and then they go to court. And then what happens?
Right. So after the hearing, there's generally not going to be any follow-up that we need from the client, but that's not always the case. There's a possibility that the judge is going to want you to go to a consultative exam after the hearing. But most likely after that hearing, you're going to expect a decision in about 6 to 8 weeks. I think it can take longer. I think after 3 months, that's when we really start to try to figure out exactly what's going on. But I think for almost all of our attorneys, after the hearing, they'll call you again, walk you through how they think it went. Even if it's just a brief 10-minute conversation, they'll give you an idea of how they think the hearing went, if there's anything that you need to do. And then at that point, it is a bit more waiting. And I think the reason that it does take some time to get those decisions is really just that they're not short, and it's not just a one-page decision. The judge has got to go through all of the evidence, the testimony, and then write that all up. So it usually is a bit of a waiting period until we get that decision. And then at that point, obviously, we contact you with the next steps, whether that's the award process or a potential appeal.
Right. And so it branches out after that. Sort of if you're denied at the hearing level, we appeal all those cases to the appeals council. And if you're awarded, we, make sure to start looking for the notice of award. And then we do financial reviews in-house to make sure our clients are getting all the money that they're entitled to. And we can appeal those as well if necessary. And you're absolutely right. They're not short decisions. If it's a denial, especially if it's a denial, it's going to be 20 pages long, because the judge knows that we're going to appeal that case and potentially even take it up to the United States District Court. And we can argue appeals that the case should be remanded or won just on poorly written judicial decisions from the administrative law judge. And so, and a little bit behind the scenes, which I'm not even, maybe but in large part because 22 years ago, I used to work for Social Security, or maybe now it's 23 years ago. But behind the scenes, there's actually lawyers that are assigned to the judge that draft those decisions. And so it's going back between a lawyer who wasn't in the hearing, who listens to the audio of the hearing, and their job is to write ironclad decisions that the judge approves or signs off on. Now, some judges write their own decisions, but as time goes on, most judges end up not doing that. So You're absolutely right. I guess one last thing that just kind of popped in my head I wanted to talk to you about, and just kind of, because I get this question a lot from clients, like, and I want to make sure like we address this. In a lot of ways, we will talk to clients and say, hey, look, Social Security is going to order your medical records at no cost to you at the application. Social Security is going to order your medical records at no cost to you at reconsideration. So then we get to the hearing and we'll get emails or a call saying, hey, and we're at the hearing level and we know based off the hearing officer going to be in what we believe the estimated time frame wait will be. And on the short end, it's going to be 8 months. And on the long end, it could be as high as 28 months.
Right.
Why don't you order the medical records on a month-to-month basis and turn it in, Mr. Evans? Or why doesn't Evans Disability, like, I called you, I told you I got this MRI, and go order it and turn it in? And there's several reasons we don't do that. Can you speak to that? And if not, I'm happy to speak to that, and maybe we can speak to it together.
Yeah, absolutely. I mean, the primary reason that we don't do that and we want to collect the medical records right around 6 to 8 weeks before the hearing is because most of our clients live in states where there's a law that you get one free copy of your medical records through your Social Security attorney for your hearing, and for the appeal of a denial. So if we were to request medical records every month for 18 months for a client, they're going to pay for 17 of those requests. And obviously, like, we cover a bit of that cost for you, and we have a policy to try to make that as financially easy as possible, but eventually it's going to increase your out-of-pocket cost. And I think that the other reason is that if we collect all the medical records at one time, we're sure that the medical records we're getting is everything from the missing date range, and that we only need to follow up on one request. So if we requested 18 different times, I honestly expect that probably one of those requests is going to be lost or forgotten about. Something could likely happen because we do have a significant amount of clients at the hearing level, and keeping those medical records as condensed and efficient as possible is probably the best idea, just so that we are sure that we're not missing anything.
Right. So the other thing too that I talk about is that when you request a hearing, it's like going to the DMV and getting a ticket.
Yeah.
And when you're sitting in the lobby at the DMV, they're saying you can fill out your forms and have them ready to go, get all your documentation together, but no one's looking at it. No one's looking at it until you get to the counter. And in similar ways, even if we requested it on a month-to-month basis, get rid of the cost idea. Okay, like let's say it was free and we could track it and everything was perfect.
Yeah.
Which is, and to your point, it's still a struggle.
Yeah.
But even if we turn it in, no one's looking at it. Right? We can turn it in every month, but no one at Social Security is going to look at it. Now, that's why we don't do it, right? Yeah. And so it's both hand in hand. It's like, look, the judge isn't going to look at it, and it doesn't make sense to run up these costs, to turn them in. And then chart notes or like, after office visit summaries are not the same as the medical record that the doctor wrote after you left. So those aren't the same either. So those are a couple of the big reasons we just don't do it on a month-to-month basis. And I wanted to make sure we address that because I do know we get that question sometimes. And there is an exception. And I know whoever our audience is, one of the exceptions is if you've been diagnosed with a terminal illness at the hearing level, then yes, we do say, let's go get those medical records at whatever point in the stage of your waiting period, because then unlike the DMV, you can cut the line, and then if you've been diagnosed with a terminal illness, and there are certain, that type of case, we start banging the drums like, hey, let us cut the line. Someone needs to look at this. Someone needs to look at this. So that's an exception. Listen, I'm so grateful to have you on our team. You do an amazing job. Not only are you, bright and intelligent, but you care. And that's really, really important. I know you believe in the mission. I'm really excited to see where you go in the future. If you choose law school, I'll be your biggest fan. Selfishly, I hope you choose to stay here and work here much longer. But it's been a great pleasure to know you and to work with you. So
thank you. Yeah, it's been a pleasure to work here as well. And I'm happy to be here and happy to be of service to people in some way.
It's awesome. Thanks, man.
Yep.